everybody. Welcome back to NASCAR Day 6, Week 2, Jordan. My name is Jeff Gluck. I'm along with Jordan Bianchi. And folks, just a warning off the top here. We want to respect your time, and we don't want you to needlessly tune in for something that's not going to be the most interesting thing in the world. So while there is enough to talk about today to fill up a episode of NASCAR teardown version, Day 6. It's not there's no bombshells, there's no spicy drama, there's no fireworks today.
Just lots of numbers.
Lots and lots
of numbers.
And we're happy to explain it to you all, what we heard. But just to let you know, like, we're not saying, tune out. But, if there was a day to miss, it's probably the one. So
math is your thing. This is your show.
Well, it started in a non-math way. It started in a very spicy way, Jordan, because at least I'll share my experience. So typically Michael Jordan has been walking into the courthouse about 8:30, right? And you get there right about 8:30?
A little bit before, somewhere in that range.
So I'm trying to make sure I get there to see the walk-in every day. Well, today I get there and none of my media friends are in the lobby, and it's kind of quiet. And I'm getting ready to put my phone in the locker, and we get a text from Bob, our friend Bob, and he says, court's starting at 8:30 today. It's supposed to start at 9. And thankfully I was there. This is like 8:20. And I'm like, okay. Well, here we go. So obviously the jury wasn't even coming in till 9. So we get in there, and Judge Bell, no nonsense judge, as you guys know, we've shared here. He's pissed.
He's in a mood.
He was pissed.
He was in a mood. He was in a mood all day today.
Yeah, he's about done with all the shenanigans. I mean, he has been, but he's increasingly
he's
done.
There. We'll as we get to that, but there's various moments throughout the day today where it was very, very clear he was over this.
Yeah. So my first 2 pages of notes here are legal wrangling, which, by the way, this took an hour. There's times when he'll come in and he'll say, okay, you guys want me to rule on this motion or this objection. They'll hash it out for, 5 minutes maybe, and then they'll call the jury in, right? This took an hour. So, okay, he says, remind me the protocol for filing objections in this case. And he goes, is it at 2:52 a.m.? Is that how we do it?
It's like your mom and dad.
Yeah. So then he's like, and then 6 out of the 7 objections get withdrawn. That's some nicely wasted judicial resources. Then there's another one at 6:50 a.m. that got filed. This does not make me happy.
That was a 15-page.
Yeah. He says, the court is not going to allow any more unnecessary documents that show minutia that the jury does not care about. That's one way he's trying to speed things along. He says things can be done quickly and efficiently, although not to my observation. The sides go back and forth about what, and this was the tone setter, honestly, for the whole day, Jordan, because they're like, what words can they put on the slides and not put on the slides? Is it alleged anti-competitive acts? The headlines of the slides. Yeah, go ahead.
And they were showing news stories, for examples, and they're like, can we show the headlines of these news stories, or is it too salacious? Can we just show what's in the story? It was all of this minutia on words you could use, different, what word was acceptable, what was not, when could the word be presented?
Yeah, and they claim, the defense claimed, NASCAR claimed that last night at 6 p.m. that the teams changed one of the damages assessments, which is what we're going to be talking about damages a lot today, which is the money that NASCAR would have to pay if they lose this case, right? And how that model is calculated, right? And they feel like they changed the wording on these slides. They changed the way how they did it. NASCAR says that they would have completely done their expert depositions differently, and they would have questioned witnesses differently and all this stuff. And they said this is, quote, beyond sandbagging and fundamentally unfair. Well, the plaintiffs are like, this is much ado about nothing. We haven't changed the calculation. We just changed a word. And if you want us to change the word back, fine. This is coming out of nowhere. And Jeffrey Kessler is saying about Larry Buterman. Apparently he has some legal argument he wants to make. He doesn't even know what it's talking about. So finally they get done with all this, and Judge Bell says, we've wasted half an hour of the jury's time because we went 30 minutes over when the jury was supposed to come in.
And they come in at 9.
And so then he also says, I will feel free to participate in the effort to get witnesses to answer questions today and for the rest of this trial.
Which he did. And we will give you examples of that as we go here, because he was very liberal with that today.
Yes, he's starting to butt in more and more to move things along when he doesn't feel like things are a witness is being evasive or whatever, right?
And even when he feels like a lawyer is asking the same question again and again and again, and he will cut the lawyer off and be like, "You've made your point. Can we move on here?"
Yes. So where we last left off with you guys on Friday, Race Team Alliance Executive Director Jonathan Marshall was still on the stand finishing his cross-examination, which Larry Buterman had said on Friday, "Hey, I got 45 more minutes." Then Judge Bell said, "I assume you've pared that down for me today, right? Like it's not gonna be 45 minutes." It's like I think I've got it under control. End up going 55 minutes.
Editor's note, he didn't short.
Yeah. And so listen, a lot of this, the Jonathan Marshall stuff is even rehash itself, but there are a couple things to sort of clean up or look at here. First of all, we've been talking a lot, Jordan, about the baseline number that how much it costs to run a cup car per year, right? Yep. The $20 million has been floated around. First, it was like we were under the impression that this was all the teams that said this. Then Steve O'Donnell, I think it was the one who said it was 5 teams that the numbers came from.
And there was an insinuation at some point, I don't remember who, but it was like mostly a lot of smaller teams too. And
okay.
I believe that's good. And Jeff's going to read them here. I can read them. There were 7 teams, and we're going to read the names here, and they certainly aren't small by nature.
Yeah, so these 7 teams that they got their numbers from, they protected their data, so they didn't know who was from what team, I think, right? But this represents 21 cars, and they are Joe Gibbs Racing, Hendrick Motorsports, RFK, RCR, Trackhouse, SHR, and 2311. So, and then Jonathan Marshall says this was actually a study to talk about cost for a car that could consistently run in the top 15.
Yeah, and they've said it before.
So this is but I'm because we had heard that Front Row, they're only spending like $14 million a year to run their cars. Anyway, this is the kind of stuff that was being sort of picked at, right? If you want to.
Yeah, and that was that too. And then Jonathan again covered the U.S. Racing League and said that was something they did explore. In March 2024, the United States Racing League, and it was designed as a leverage in negotiations and trying to get a better deal from NASCAR. And they quickly abandoned that shortly thereafter, though. Teams didn't want to do it. And I think this is because it's going to come back to circle in later as we go into damages and other things. There was 2 teams that particularly weren't interested in it, and that was Hendrick Motorsports and Team Penske.
A little side note here, unrelated to anything. We did find out today that Paramutual betting is being currently negotiated. So this is something that I guess both NASCAR and the teams are working on separately. The teams decided to join NASCAR. So again, this is unrelated to the trial itself, but Paramutual betting is like betting that's contained. So you're not betting. It's the sports book isn't setting the odds, right? Like the odds are changing when you're at a horse race track. It's changing, right? So you can envision that potentially they could have betting windows or some such at NASCAR tracks like they do at horse racing tracks. And then you could bet on drivers to win, place, or show, something like that. And people could bet live at the track, bet against other bettors, and the odds would be changing, that kind of thing. I'd imagine is what they're talking about.
And quickly here, another Judge Bell note. Some documents were being submitted, and one of the lawyers was trying to read it, and Judge Bell's quickly snaps, "I can read."
Oh, I didn't even hear that.
It was correct. That was like, oh, we're on. Game on.
We did hear a little bit more as well from Jonathan Marshall and some text messages about how the whole, the deadline thing went down, the infamous September 6th date, because at first we had heard on August 30th, so a week before, NASCAR brings up the point that there's a text that says Jim is making the rounds, individual calls indicating he really needs to get this wrapped up in 1 week. So NASCAR is saying, you all are acting like this September 6th deadline was out of nowhere, but we're telling you on August 30th here that Jim is calling everybody saying, we really need to get this wrapped up. Then on September 4th, 2 days before, there's a text from Jeff Gordon to Jonathan Marshall, and Jeff Gordon's frustrated with Curtis Polk. He says, I'm about to go off on Curtis. He's delusional if he thinks we are still negotiating on the 5 points, aka like the four pillars.
The 4 pillars.
Right? And Jonathan Marshall says, I agree with you. This is the mandate from NASCAR, right? And then the big teams end up signing first. It looks like Hendrick, Penske, Gibbs signed, so that indicates the other teams would sign at 6 p.m. on September 6th.
And there was no favored nation clause in there, and that was something that smaller teams were worried about. And once they
Right.
saw the bigger team sign, and they saw what the team signed, then they kind of came around and they signed, and that basically got the dominoes rolling. And in a quick, relatively short order, 13 teams had signed the document.
Yeah, if you checked out our episode last week, I actually mischaracterized that or messed that up, because this most favored nations clause, which again is like NASCAR wanted to be able to negotiate with different teams on different terms. So they wanted to give the big teams certain terms in the charter deal, and they wanted to give the small teams certain terms. And they did get to do that. There is nothing in the charter agreement that says all teams will get the same terms. So what happened ultimately was some of the teams, smaller teams, were holding out, but when the bigger teams signed it, they felt like, okay, well, now they're not going to get better terms than us, so they signed it. So now these are the best terms we're going to get too. But there's still the teams never got in there, and that NASCAR can't give a better deal to different teams. They can give one deal to Hendrick if they want. They can give one deal to Rick Ware if they want. But ultimately, the teams that signed it, I guess, all got the same terms that day. We also have a text from Jonathan Marshall that NASCAR is trying to show here, talking about how the teams got a raise of more than $700 million from last deal, and he says, "quote That's a win in my book." So they're NASCAR again saying, well, here you guys are saying that you didn't get what you wanted, but you're saying your text. It says to Aspire executive, it didn't say who, but it says that's a win in my book. So
Aspire president.
Aspire president.
That's what they said. Yeah.
Okay. Also, there was talk about how, there was 45. There's this whole thing, right, about the teams ended up getting 42 to 45% of the media rights revenue, and NASCAR had asked Jonathan Marshall earlier about how, well, wait a minute, here's these other messages from you guys saying that you didn't want this, like you guys were fine with this. Well, NASCAR or the teams go back and say, yeah, this was after NASCAR had already rejected the $720 million. That's why they're saying they're fine with it. And then finally, we hear that Joe Gibbs, Roger Penske, and Rick Hendrick spoke directly with Jim France because, quote, they have a ton of respect for Jim France. They're friendly. Some of them have known each other for more than 50 years. And the Jeff Gordon text about Curtis Polk saying he's crazy, he's delusional if he thinks we're still negotiating was because Rick, Roger, Coach Joe Gibbs had already tried talking to Jim France. Nothing happened. There was no movement. Yeah. And so all he was saying was he's crazy if he thinks he's going to move now. He's not moving is what Jonathan Marshall says on the redirect. So that's pretty much it for Jonathan Marshall. Is that correct?
Yeah, it recaps kind of what we heard, which was that the teams did get an offer on August 30th. They were at least aware that September 6th was the cutoff date and negotiations would end then. There was some revisions. We didn't learn today, but just kind of recapping quick, there was some revisions between that August 30th offer and the September 6th offer. Yeah,
So the rest of the day, this is 11 a.m. now.
Numbers time.
The rest of the day is an expert witness, Dr. Edward Snyder, Ted to some people. He's an economist. And the reason that they have to do this, we'll have our friend Shannon McMinmy on later, who flew on a red-eye flight from Seattle overnight last night to be in the courtroom with us today, just for funsies. And she will join us at the end here.
She picked a really boring day.
She picked the worst. She thought this was going to be the Children's Day.
Yeah.
And
but tomorrow, I think we're going to get a big day tomorrow.
We're going to hope, but it's moving slow.
But it's shaping up to be a big day tomorrow.
Yeah. So listen, they have to do. She'll explain more about this perhaps, but they have to do these expert witnesses because they are the numbers people. So, when we hear about, are they, did they do anti-competitive acts or not? He can testify to that, and he can also testify to how much NASCAR should have to pay. And he's the one that's calculated all that out, that gives the teams the idea to ask for how much money they need to ask for. Okay. So listen, this guy, obviously well qualified, right? He's a former dean of 3 business schools, Yale, University of Chicago, and the University of Virginia. His specialty, or his subfield is industrial organization, which is a field that deals with antitrust issues. So he's the person that you want to go to. He's been part of 30 antitrust cases. He's been in court 12 times, and he's actually mostly been on the defense side of these. But this time he's on the plaintiff side. By the way, he also testified in Deflategate.
Worked with Kessler on that.
Yes, and so now he, as Kessler points out, he's been in both the a trial involving Tom Brady and Michael Jordan.
All right, how about that?
Yeah.
And also used to work for the U.S. Department of Justice as a former staff economist.
Yes, so this guy obviously knows what he's talking about when it comes to this sort of
He's
thing.
got the credentials.
Yeah. So listen, again, I'm just warning everybody that no, we're not taking offense if you're like,
Let's just don't tell people.
Okay, all right. We're gonna tell people what happened.
Those numbers are coming. There we go.
Part of this first part is going to sound like a review. If you've tuned in every minute of our podcast over the last week, part of this is going to sound like a review, but this is where Jeffrey Kessler is starting to put all the puzzle pieces together. So he's taking various things that we've heard of last week, and he's stacking them into a case to where the expert witness can go, okay, see, this violated this or whatever, right? So, and it actually, honestly, even for me, Jordan, as much as we've been immersed in this, I was like, okay, I see this makes sense.
And I will say, it was actually, I think going into this, we're like, oh man, this is going to be dry, and it was actually educational.
Yeah.
In a lot of respects. I mean, it kind of dragged down, but these things tend to do that. This was educational, though. You did learn a lot, and it reinforced some things that we kind of knew in terms of the numbers.
Right. Okay. So
here we go.
So first of all, we start with the allegations here, right? And this is, honestly something, Jordan, that again, we should probably be doing a little bit more on the podcast every day. That what is this going on? What is this case about? What are they trying to prove? What is, we haven't really, we're just getting into so many of the facts and all this stuff, but we haven't talked too much about the big picture thing. So this is a good time to do that, right? Because there's 3 things. First, that the allegation is that NASCAR is a monopolist. Well, no worries there, because that's already been decided. You'll recall that before this case even started, Judge Bell found that NASCAR is a monopoly in premier stock car racing, right? And so in Snyder's, terms, that means you can either say yes, or you can say no and not compete, or you can say no and compete as open, but he says that's not possible due to the revenues, the economics of competing just for purse money are really bad. So that one's out of the way. We already know NASCAR is a monopoly, period. It's not a dispute here.
What is a dispute is whether they did anti-competitive acts, which is illegal, and that where we're at.
Exactly. And so what are those anti-competitive acts? Well, a big one here is things that you do to maintain your monopoly power, right? So you have a monopoly, and if you do stuff to extend or continue that monopoly, that can be illegal. And so we will get into that. And then the third one is the allegation that the teams were actually injured by this anti-competitive conduct that NASCAR did, which is where the money would come in. So did these actions to extend the monopoly and continue the monopoly harm the teams? That's what's at stake here. So Snyder says, listen, from my findings, NASCAR has created barriers to entry of another competitor through 3 different ways. He keeps coming back to this: the tracks, the teams, and the cars. Okay,
which is a really straightforward way to put things.
Yeah, it makes it simple, right? Like, and so basically, he has to look at this in 2 different ways as well. He has to look at this in the real world, the actual world, what is happening now, and the big term of the day.
Oh my God, how many times do we hear this term? A lot.
But for the but-for world, that is BUT-FOR. And that means in a world that would have happened without these circumstances. Jeffrey Kessler's example, which actually helped me today, was he said, let's say I am walking up to the witness stand to talk to you, and there's a banana peel on the floor, and I slip on it and I fall down and hurt myself, right? Well, that's like the actual world. I slipped and fell and hurt myself. The but-for world is, if that banana peel hadn't been there to injure me, what would the outcome have been? So this, every time you hear the but-for, is like this alternative universe, essentially.
Hypothetical.
Yes.
A hypothetical is probably the best way, I feel like, is when you hear but-for, hypothetical.
And so what he's doing is he is trying to evaluate how things would have looked if NASCAR did not have this anti-competitive conduct, alleged anti-competitive conduct, right? So first of all, he says, it's interesting. He looked at all these different sports, right? He looked at 8 different sports. And he finds that NASCAR is an outlier in the sense that they own the venues and have exclusive use of those venues. He claims F1 does not have exclusivity clauses, although under cross-examination later, that's a little bit in dispute. He talks about how, you look at the PGA with Live Golf, you look at WNBA with Unrivaled League that started. He says in those cases, it's clear to him that there was changes that were made then that benefited the parties. Like the PGA ends up coming up with more money for the players after Live Golf exists, stuff like that, right? So he looks at, and how he comes to this conclusion is, number one, right? He looks at the breakaway series reaction that NASCAR had. We talked about this, how they wanted to lock up the tracks. So he said that getting control of and putting exclusive agreements with the tracks left few for a potential entrant. You look at, how there were these exclusivity agreements. They started in, they were negotiated in 2015. They started in 2016. There was never any exclusivity agreements in sanction agreements before the charter system came to be. And so for him, he says, by the way, all these negotiations that are going back and forth, he said, I've heard, he's been able to sit in the trial because he's an expert. So your experts are allowed to hear the testimony, unlike the other witnesses. Yeah. He says, I'm sorry, go ahead.
No, I was just gonna say, if you're a witness in this case, you cannot be in the court before you testify. You have to be outside the courtroom. You can't even talk to anybody. You're not supposed to have any communication with anybody about this case. Once you testify, though, then you can be back in court.
Yeah. So he says, by the way, I've heard a lot about these negotiations going back and forth. And he says, these are negotiations between a monopolist and the teams who have no other option. It's either go ahead and participate in the sport or not. He notes that they're under NASCAR's decisions of what they can do, what we can do. There's all the options are like prevent the teams from doing this, lock up the tracks, do this. He says there's no option where it says pay the teams more.
Yeah. Not that we're going to go ahead and pay the teams more, but instead lock up the tracks.
So here we go now as he starts to break things down. So again, there's 3 parts here that he says are exclusionary, right? It's the tracks, the teams, the cars. The big one for him is the tracks, I would say, right?
Correct. This was a heavy focus today on the tracks, which seems to be the case for a lot of what I think the teams are doing is trying to show that, hey, this is their action. They were worried about a potential breakaway league. They have focused heavily on the track sanctioning agreements last week. They're doing it again today with their expert, and they're showing NASCAR's action, and that NASCAR is afraid that these teams would run to Speedway Motorsports and say, hey, we want to form a breakaway league. You guys want to partner with us? And NASCAR, worried of that fear, as emails and texts and everything have showed, worked to lock up Speedway Motorsports with multi-year non-exclusive or exclusivity agreements with the tracks.
So from his view, he finds that NASCAR has an interesting business model from his view, because in other forms of motorsports, he says, if like F1, right, they're going to pay to have an F1 race come to them. In NASCAR pays the tracks. They do get some money back, but NASCAR overall is paying the tracks more than they get back. In fact, he says NASCAR paid the tracks $311 million in net payments. He says that's really large. I wonder why it's so large. Why is NASCAR paying the tracks? And he says, because usually you'd be like, oh, the team owner has the right to host or the track owner has the right to host these events. They want to host lots of events probably. But he says in his mind, they're paying the tracks because 3 words, paying for exclusivity. He notes that the Bank of America stadium right out my hotel window here, was not prevented. That's obviously where the Carolina Panthers play here in Charlotte, right? They had the ACC championship there a couple nights ago. He says the ACC is not prevented from playing at Bank of America Stadium because they have exclusivity agreements, right? But he says that's essentially what's happening in NASCAR. So his opinion of how the tracks look is they're definitely anti-competitive. The restrictions on the tracks were supported by payments to the tracks. They tied up the tracks and protected NASCAR from entry of a competitor series. The impact was to extend their monopoly. This is anti-competitive, clear and simple. So that's number 1 from his view. And again, we will get into the cross-examination. NASCAR disagrees, but this is his view. Number 2, to a lesser extent, but to an extent, is the teams, because we know there's this goodwill provision that you guys have heard about, which says, hey, if you're a team owner in NASCAR, you can't invest in or participate in another stock car series. And in fact, even if you're a 10% owner in a cup team, you can't be an owner in another stock car series. And also, if you leave NASCAR by just giving your charter back, you have to sit out for a year. So what does that all mean, though? Like, how does that fit into this? Well, to him, it means there's less supply of potential owners for a rival series. That's why they've kept bringing this up, because it means there would be less potential owners to form a rival series in the first place. That's why he's bringing up these restrictions about, well, you can't go anywhere, right? And then the cars. We know that the Gen 6 car didn't have any intellectual property protections on it, right? So, you could race it anywhere in theory, right? Whereas the Gen 7, you could take it to a copycat series. Was what NASCAR was worried about that. Mm-hmm. Gen 7, though, it's restricted. You can only race it in NASCAR events. Sole purpose is to use it in NASCAR. And he says, I'm sorry.
No, please go ahead. You're going to say the same thing.
To me, as an economist, this situation bothers me. Team owners are building the car. They technically own the car, and it's their most important piece of equipment, but then they can't use it outside of NASCAR. That's anti-competitive.
They also don't own the cars, technically. They buy the chassis, they buy the parts or anything, but they have to basically return them to NASCAR. So
it's like a license to run the car,
exactly.
Basically. But anyway, he says in his view that each one of these reduces the likelihood and the viability of another series coming in. He believes that they all actually tie in together, because from his view, when NASCAR is concerned about the entry of another competitor, they take steps to try to prevent it. So that's where we get onto that one. And now we're onto the damages model, Jordan.
More numbers. This is where the numbers really,
yeah.
This is really, all you math geeks out there will love this part.
We'll try to make this as simple as we can.
This is all you.
Thanks.
Listen.
Okay. So again, we talked about the but-for world, right? He's got to come up with a variety of models and damages to figure out exactly. He can't just pick a number. He's got to show his work, right? Like we all had to do in high school. Instead of just to make sure you didn't just use your calculator, you got to show your work to solve the problem, which is what he does here, right?
I flirted with the teacher.
You flirted with, that's how you didn't have to show your work? Okay. So he had to pick, first of all, he's got to pick a benchmark to do this. And you have to, in order to pick a benchmark, you have to pick a similar industry and also a business that does not have anti-competitive conduct from his view. And he later goes on to say it doesn't have to be apples to apples thing, but it has to be basically as close as possible.
There is, and he does say there is no perfect comparison, really.
Yeah.
But so you have to kind of just pick and choose a little bit and find the best one that fits. And what he say is what he settled on was Formula One.
So he says that, you know, F1 is pretty similar to NASCAR in a lot of ways. It operates, except they don't own the venues. They don't have exclusive deals. They don't have non-compete clauses for their teams. By the way, side note, F1 revenue 7 years ago was a total of $1.8 billion. Last year, in a span of 7 years, it is $3.4 billion. That's how much F1 has grown. But F1 pays out from their league revenue on average, not per, there's some years it varies, but on average, F1 pays 45.6% to their teams. So 45%. NASCAR, for most of the time in question here, until this new charter deal, paid 25% of the media deal.
Quickly, too, as he's looking at F1 and the numbers and everything, then I just want to say the years. 2017 to 2024, which is the span of the charter agreement that NASCAR was operating on, the NASCAR teams were operating under previously.
Now he can only use 4 years to get his damages. It's a calculation.
Yep.
I guess there's a statute of limitations.
And that was established at the very point.
So he's using 2021, 2022, 2023, and 2024 for his 4 years that he's looking at this, right?
And one of those years, 2021, was not the next gen car, too.
Right. So here's how he has to come up with the damages now. Are you guys ready for this? There's 3 parts.
There'll be a quiz on this later.
Yeah. Okay, there's 3 parts. It's actually not that complicated. Number 1, you have the lost profits from what you would have gotten in those 4 years. So to him, well, we'll get into, I'll say what they are first, and then we'll go in how he got each one. Number 2 is the reduction in the team's value. And number 3 is additional other revenues they should have gotten in his mind. Okay. So he says, like, for instance, here, the teams, all the race teams got $202 million. This is for 2311. They got $202 million from in those 4 years. And this includes their sponsors too, by the way. But had they gotten 45% of league revenues instead of 25%, that's what they're saying they deserved here, because that's the benchmark, right? Then they should have gotten $253 million. So the difference is $52 million rounded. So now he's going to subtract the driver salaries from that, because he's saying if this had been a different financial model in the but-for world, then they would have had to pay the drivers an extra $11 million. So in his imaginary theoretical world here, the drivers are getting paid a lot more.
Because the teams are making more. That's what he says. When the teams are going to make more money, they're going to spend more money on drivers' salaries. And that's something we've heard a lot about in NASCAR over the last decade, where driver salaries have largely gone down as the teams have made less money. And so the reverse would also be true.
So just from the media rights payouts alone, nothing else, no theory, right? This is just, if they paid you 45% instead of 25%, 2311 is owed $41 million and Front Row is owed $43 million. But my friends, that's just part 1 of this calculation. So you got those on the books. Now we got to talk about the reduction in market value. Okay. This is where it gets more complicated. You got math, multipliers, all this stuff. But basically, to make this as simple as possible, sports teams, we are told, are valued based on their revenue times a multiple of that revenue. And he's got to decide how to come up with the multiplier, right? And for instance, we are shown that the Los Angeles Lakers, when they just had their sale, it meant they were valued, their multiplier was 19 times. The highest in NASCAR that he could find was Front Row. That was 2.6 times. That's their multiplier, 2.6. So we're also told later, by the way, I mean, we were told earlier, like Scott Prime's email showed that he thought that if the teams had permanent charters, they could have 5 to 6 times valuations. Anyway, he does this calculation, right? And he says, okay, it's 2.6 multiplier right now in F1. That's the top. Well, the lowest, or in NASCAR, the lowest in F1 is 4.3. So he says, okay, I'm just going to be conservative here. I'm not even going for an average or the highest is what he's saying. And I'm going to multiply all this stuff, the difference times this multiplier. And he comes out and he says, I've got 163.8 million for 2311, and I've got 96.4 million for Front Row. So again, he's saying that's conservatively his estimate. He's erring on the most conservative side. He picked the lowest F1 to compare it to because the highest F1 is 5.7. And he picked the highest NASCAR one because the lowest NASCAR one is 1.2 multiplier. So that's a lot of money. But we continue. There was some lost revenue, and this isn't that much money, but, well, kind of, but comparatively, I guess. So the teams didn't get, they ran as open teams for the last 16 races of last year. You guys all know this, right? Because they lost their charter status when the appeals court turned it over. So because of that, 2311 ends up losing $10.7 million at the end of last year, and Front Row lost 9.4. So those three categories we just went through, the missing gap from the 45% to the 25%, the theory from the multiplier, what they should be worth if they were like the lowest F1, and the lost revenue, you add it all up, and they are asking for, in this case, $215.8 million for 2311, $148.9 million for Front Row.
Combined equals 364.7.
All right. So here's, there's I guess a NASCAR expert, one of their expert witnesses had written a briefing, Jordan, during all this, and said, if we were going to pay all this much to all the teams, the 45% and all this stuff, it would make NASCAR go insolvent. They would go out of business because they would have had to pay $300 million more to the teams collectively.
In a but-for world, yep.
Collectively. And, Snyder says, I don't really buy that they would have gone insolvent. And here's why. He says, NASCAR has $2.2 billion in assets. They are worth $5 billion, according to Goldman Sachs, I think he said, right?
Correct.
They have an amazing credit rating because they had debt and they paid it back really quickly. They, from 2001 to 2024, they made an average of, NASCAR made an average of $250 million a year. The France family, over a 3-year period, has collected nearly $400 million in shareholder distributions. Remember, the France family owns 100% of NASCAR, so they themselves collected $400 million. Then he says, there's a $7.6 billion media rights deal, and he doesn't understand why they have to pay $130 million to the tracks. He says it could be zero from his view. So he says that listen, if NASCAR wanted to, they could adapt and get creative like the PGA Tour did. PGA Tour brought in a $3 billion investor. They sold part of it, right? They sold a stake. And so he's saying that NASCAR could do the same if they need to raise the money to make the teams whole.
Yeah, the PGA Tour also added more lucrative events, he says, and NASCAR could have done something like that. Basically, you adapt your business model to survive.
Well, obviously NASCAR doesn't agree with this, right? So it's time to cross-examine. And I got to be honest here. As much as Larry Buterman is sort of like the bulldog that won't let go and just like harps on his points, think about this, Jordan. If you were NASCAR or anybody and you needed somebody to chip away at the other side's arguments in court, are you not hiring Larry Buterman to be your guy?
Yeah, I got a couple speeding tickets I need him to take care of. He's my guy.
Because think about this, folks. As much as, and this was at 3:00 we started the Snyder cross-examinations. This was 2 hours of just
nonstop, to the point where the judge multiple times interjected and says something to the effect of, "I believe you've made your point. The witnesses answer the question. Can we move on?"
Yeah, he was getting exasperated. The judge
and it happened 3-4 times throughout this 2 hours. Which, by the way, he's not done.
He's not done.
We've got more tomorrow.
But as painful as this 2 hours was, think about this. Every little bit that Buterman can poke a hole in this damages model. I mean, we just talked about it. It's $364 million total or something. Yeah. Plus it would be triple damages, right? But so every little bit he can shave off, Jordan, that's like millions, tens of millions he could be shaving off the model, right?
Yeah. And his idea here isn't to completely blow up these projections and everything like that. It's just to poke holes in the theories and how you got these numbers and you missed this. Mm-hmm. We're going to go into this. How you missed this, or you didn't think about this, or hey, did you not realize this, and these kind of things. And you poke enough holes in this, and the jury looks at this more skeptically, and they're like, oh, well, maybe these numbers aren't as what we thought they were, and that's how you win the jury over.
For instance, he talks about how you're saying that, is for these 4 years. Your damage model is based on these 4 years, right? Well, the next gen car doesn't even come into to play till 2022. So you're saying that the car itself with the IP protections is an anti-competitive act. Well, that wasn't the case for the first year. You know what I'm saying? So, and they go around. I'm like overly simplifying here, but basically, Snyder says, well, okay, if you want to say I'm off by a year, give or take, or whatever, but that could ultimately, maybe that changes the damages model. You know what I'm saying? Like, so it's these little things, right?
And there's also, he talked about before, Snyder said that F1 teams don't have to agree to a non-compete or don't have a non-complete clause. And Larry, the lawyer, NASCAR's attorney, came back and said, no, that's actually not the case. Like, actually, here it is. Here's evidence that says that they do.
Yeah, but see, it was interesting though, because they say that F1 has an exclusivity clause, but then Snyder says, well, McLaren runs, and it says you agree not to promote another single seater series, like open wheel series, but obviously McLaren runs both F1 and IndyCar. So
there's clauses in the Concord agreement though that where IndyCar is there's a little bit of complications, there's loopholes, and there's also a point in this today too where he talked about how NASCAR teams can't compete anywhere else, and you're like, well, NASCAR teams compete in other series, and
yeah, it's so far down the minutia.
It's so muddled.
Yeah. But 3 things we did learn is that, because remember for a while here, especially before the case started, NASCAR's acquisition of ARCA was like, see, that's anti-competitive.
It was mentioned in the initial lawsuit.
Right. And now, at least Snyder says, in terms of like calculating his damages, he's not factoring that. He's saying that's not an exclusionary act. Them buying ARCA is not, they're not looking at it as they bought a competitor. And that seemed to be a thing early on.
Yeah, and it was that I noted that today in my notes because that was really the first time we've heard ARCA. Because remember before when this lawsuit was filed, a little over a year ago, that was a big thing. I mean, that was listed of They bought ARCA in 2018 because they were worried that the teams could go buy the series. We haven't heard anything. I don't think we've heard anything about ARCA at all.
No, but they haven't presented the text to O'Donnell saying, you guys need to go buy ARCA
none of
the teams.
No smoking gun. It's been all SRX focused.
Mm-hmm. You're right. Maybe they did it to simplify. I don't know. Lots of Shannon.
Maybe there's no smoking gun. I don't even know.
Yeah, maybe. Yeah, maybe they couldn't find anything that said.
You would. Yeah, I'm presuming like if there was that smoking piece of evidence, like we probably would have seen it by now. Like it would have made sense, you know.
Yeah, that's true. Yeah, they probably just would add it to it. Yeah. I mean, honestly, at the time they bought ARCA, I don't think anybody was like, oh, that was going to be a competitor, and they,
No, I mean, in NASCAR's defense, we'll say is like we bought that series to keep that series alive, because if we had not bought that series, it was on its way out. Especially with COVID and everything, they would have gone away. They bought it to keep it thriving.
He also says the NASCAR's acquisition of ISC to take the tracks in-house, merge as a company, was not considered anti-competitive from his view. And he also, this was interesting too, his damage model, like the but-for world, did not take into account permanent charters. So he's saying actually probably would have been even more if I calculated as permanent charters, but I wasn't even, in my imaginary theoretical world, I wasn't even saying that they'd have permanent charters and making the damages go up from that degree. That has nothing to do with his thing, he said. Man, there's so many other, like there's just back and forth, like Buterman will say, and you didn't do any work to determine that, did you, sir? I did a lot of work. This is all just made up in your head in a but-for world, isn't it? This is not a theory. This is not conjecture. This is based on facts. Then, like, here's another example, like how far down, they're saying, oh, they brought about SRX, SRX. And Snyder's like, yeah, but SRX was not a premier stock car racing series. So Buterman goes, Denny Hamlin raced in SRX. Are you saying that Denny Hamlin is not a premier stock car racing driver? And again, Snyder's like, it's the series. It's not it was trying to, anyway, it's just like, it was like sort of exhausting stuff like this. He got pressed for a really, really, really long time on a hypothetical entrant and how, like, for instance, like, hey, from 1948 until now, there's never been a NASCAR competitors series. So why would there suddenly be one in 2016? Why would there suddenly be one when you started your evaluation, right? For instance, he also says these other leagues, how, Live Golf, Unrivaled, those leagues didn't respond until there actually was a competitor. So you can't assume in your but-for world that NASCAR would have seen a competitor coming and just responded to the potential threat by giving the teams more money, which he says is $1 billion. He keeps saying your theory in the but-for world would have been $1 billion you're trying to give. You want the teams us to imagine that in your theory. So, yeah, it's stuff like that. But he, again, Snyder says they did respond to a potential viable entry. They didn't wait for it. That's why they did all these things. They locked up the tracks. They weren't waiting for it, but they didn't pay them more money. They did the anti-competitive acts. And his but-for world, he's saying instead of the anti-competitive acts, they would have actually said, we value you. We want you to stay here. We're going to give you more money. That's what his alternate universe is. But that keeps getting picked apart.
And he talks about Formula One, and there was potential, and this was, again, muddled, but he talked about some potential Formula One breakaway series startups and how that helped the teams get a better deal with the league over there and a better Concord agreement, which is basically a charter agreement, for lack of a better analogy. And so competition drives the leagues to provide the teams or players more money, more rights, more power, that kind of thing.
Judge Bell is starting to lose his patience at this point. He says, you've taken 3 or 4 runs at this line of questioning. I think you've gotten the answer you're going to get to. Again, later he says, you've taken a good number of runs at this. You've gotten the answer you've gotten. Move on. We also do learn, another side note, Jordan, interesting nugget. NASCAR claims that Furniture Row Racing left because JGR doubled the technical alliance price. We didn't hear the exact numbers, but that the alliance they had doubled and JGR ran them out of business, NASCAR is saying.
Which is what we've heard from
we heard they've raised it, but I don't know if it doubled. Has it been out there that it doubled?
It was pretty Yeah, I mean, it's been out there.
Okay, my bad.
No, it's not. No, I mean, it's just I don't know if we know the exact numbers per se, but like it's been out there that was a large part of why Barney Visser decided to close down.
Yeah, but then there's like some more like, they're trying to pick apart his argument about F1, and he's saying, well, F1 has other tracks that could race, because he's like, well, how come Baku and all these places have crazy long sanction agreements with F1? And Snyder's like, well, because there's other F1 tracks that could be out there too, so it's not anti-competitive. And Buterman says, what evidence do you have that there are other tracks for Formula One? And I want to be like, that one I don't think stuck. But yeah, I mean, I will say we also did find out that in Snyder's opinion, NASCAR has two of the best experts in the whole world ready to testify for them. And that's coming later in this trial. So
more Judge Bell's snappy retorts, piece of evidence there that was kind of going back and forth whether it should be submitted or not. The judge goes, the jury will recall the evidence probably better than the lawyers.
Yeah. And then finally he goes, this was his most irritating moment. He goes, it's been explored. Like he was just, it was this really came off as like, and I know you're going to say this is me, but like everybody, you all have a friend who is like never wrong and like will not let anything go and just keeps harping on it until they win the argument, and they will not let it go. And you're just like, God, you're so annoying. And I know you're going to say it's me, but it's not. It's not. But
that's a word.
It was like we kept looking at the clock, and you're like, oh my God, is he going to wrap it up? And then he would bring up one more thing. It was like Buterman wanted to like punish Snyder for like even existing on this planet. He was just going to anyway.
You want to be more ahead with his numbers.
Yeah. So then we do find out too that, and this probably would have made such a small difference. Snyder included some open runs from Corey Haim, Juan Pablo Montoya, and Kamui Kobayashi. And I have the information here of their finishes.
Yeah, they ran in 23XI's open car during the 2024 season.
So they got some money from that, and he put the open money from the purse in. They finished in those races 29th, 29th, and 32nd as open cars.
Remember, open cars make significantly less than chartered.
And he's saying, but you put those in the calculations for how much they should, you're just like, God, this probably makes so little difference. Anyway.
And he did the Snyder did say I was careful on both ends.
Yes.
When going through the revenues and everything.
So we end the day, and Judge Bell is thinking that things are moving so slowly, you guys, that he says to the jury, can you guys make it in at 8:30 tomorrow morning? Is that a problem for anybody? And can we stay till 5:30? If we do that for the rest of the week, we'll get 4 more hours out of this week. So now we're going to be doing court because normally it's 7 hours a day because you have the 1 hour lunch break. Now it's going to be 8 hours a day. So we will be coming to you on the teardown 30 minutes later for the rest of this week, because we will be staying in court for a long time. But Judge Bell really wanted the plaintiffs to wrap their case, hit the wrap it up button.
But it ain't gonna. You want to wrap it up by tomorrow, but it's not gonna happen because we still have. If my list is here, the plaintiffs are still gonna call Jim France.
Well, first of all, they still got to finish.
They still got to finish
tomorrow. Buterman said he still has more.
Yeah, we don't know how much longer that's gonna take. Who knows? But then we still have for the plaintiffs, Jim France, Richard Childress. They have an accountant, and then Steve Phelps. Right. And that's what we know of.
And the order is the accountant, Steve Phelps, Richard Childress, Jim France.
That's what we know of. There might be someone else.
No, they said that's all. They said that's all.
Okay.
Now get this, you guys, and let's hope this is not the case. Supposedly, the defense has 15 to 16 witnesses to call. They can't do that, right?
They get equal time.
I know, but anyway, let's bring in a woman who flew cross country on a red eye because she has so much FOMO. Last minute over the weekend, I got a text Actually, it was yesterday. I'm getting on a red eye tonight, and I'm flying for 2 days. I think she thought it was going to be Richard Childress and Jim France. Instead, she got the most boring day, but she is an attorney, so she's used to the boring minutia. Shannon McMinmy, let's bring her in now. And Shannon,
hi.
How are you doing? And what was your? See, you've heard us talk about all these people. Now you got to see them.
Now I've got to see them. Got the lay of the land. Please do note the lovely matching artwork we have from our different rooms within the same hotel. I will say it was not as boring for me as it must have been for everybody else. Believe it or not, that was not a particularly atypical expert exam. So I know it felt like Buterman was taking forever and knocking, things. It was pretty much what I expected, except for the repetitiveness. So have I ever had a judge open court, did not even say anything other than, well, somebody needs to tell me what the protocol is because it certainly isn't emailing at 2:52 p.m. or a.m. That was very unusual. And he definitely was fed up. I will say that none of the witnesses today belabored answers. They all answered the questions. It was more that Buterman wasn't getting the expert to concede the points he wanted the expert to concede. So he kept trying to circle back around in different ways. And that's where Judge Bell finally is like, you covered this. You've gotten the answer. It's not changing. It's time to move on. So I don't think it was, I think the witnesses all answered questions relatively concisely for the questions they were asked. I certainly think Jonathan Marshall did, though there was one thing that he had to throw in there, which is when Jeff Gordon was described as a co-owner of HMS and a member of the TNC, Jonathan Marshall felt the need to add 4-time champion and Hall of Fame race car driver.
Right, he did.
But other than that, the witnesses were generally answering the questions they were asked without a lot of back and forth teeth pulling. It just got to be a slog with the expert testimony, but it was really great to get the lay of the land and see everyone and where they were and to kind of watch the jury digest the information. So might be the most exciting day ever for you guys. I enjoyed my time.
Yeah, I want to talk to you about the jury. I think we've talked about the jury before, but today particularly, this is a lot for them to digest.
Yep.
A lot of numbers, a lot of information, a lot of minutia. It felt overwhelming for maybe us even at times. I can't imagine what it was like in the jury box.
They were clearly over it by 4:30.
And they looked like that. Honestly, that look that they had today was very similar to what they've had most days by 4:30, 5 o'clock. It's a lot for them, and I feel terrible for them. How particularly, though, when you're dealing with numbers and things like this and formulas and all of this stuff that it can be a lot to digest. How do you, as a lawyer, help the jury process this and remain interested to digest this?
Well, I think you do what Jeffrey Kessler did, which is have a visual to go along with it. Professor Snyder, and I'm going to go with Professor as he identified that was his preference, did have a very professorial demeanor and consistently looked at the jury and engaged with them when he was answering questions, regardless of which attorney asked the question. Definitely. So people have asked, the jurors do have notebooks. I definitely saw jurors taking notes during his direct examination. And at one point, one juror was flipping back in the notes during the cross exam. So they're definitely paying attention. Having the visual helped, which is why there was that overwhelming fight about the visual at the beginning of the day, because the jury is going to pay more attention to that. It seemed to be much ado about nothing at the end, but I think that was helpful to put the numbers up and then have him walk through his formula with step 1, press the button and it appears on the PowerPoint. Step 2, press the button and it appears on the PowerPoint. So I think having that visual element was helpful. I think that it's the theory discussion was pretty straightforward once you understood what his points were. And Professor Snyder did keep circling back around to what his 3 big things that he was identified that what NASCAR was doing to prohibit competition or to prevent there from being anybody entering the marketplace. So I think he did a nice job with explaining that and explaining the numbers. It just Where it got difficult to follow is when Mr. Buterman started giving him hypotheticals and questioning the choices he was making, but there was no context for the jury as to what those mean. Like, the jury doesn't know or really care, like, about some of the real, like, we care as fans to know if the reason why Front Row went out of business is that suddenly their alliance with JGR became cost prohibitive, or all the other reasons that might be out there. But for his analysis, that doesn't matter. For his analysis, they left the sport because it was no longer economically feasible. And he's an economist, so that's all he's going to talk about. So all of the things that might have had some interest to us as fans as to understanding some of the backstory. And by the way, none of those questions get in as fact. Like, the fact that you pose the hypothetical to the witness, like, well, what if JGR went out of, or what if this one was the reason why Furniture Row went out of business? That's not a fact. That's before the jury, and it just went right over their head. It doesn't. I think the only thing that resonated with them is the repeat that both witnesses identified. It's not typical to have your championship winner immediately go out of business the next year. So I think the more palatable to the jury to understand is the direct, and that will be the case with all of the experts, right? Because they're telling a story, they have the visuals, they make it digestible for the jury, they have analogies that they built in, like the different sports analogies he was using today and the other comparators, so that juries can connect with it even though they don't necessarily have a lot of knowledge about motorsports or NASCAR. It just gets really hard not to lose a jury on the cross-examination of an expert. And to be clear, NASCAR was not trying to impeach or call into question Professor Snyder's expertise or his background or his skill set. It was really, how did you do these calculations in this case using this information, and why didn't you consider this other information? And in those instances, you're always going to get this repetition answer back of, because it wasn't relevant to my analysis, I'm using this. You want me to use that, and I can't tell you, and you probably heard this how many times, that Professor Snyder's like, well, that has nothing to do with this. That's just confusing the matter. You shouldn't be looking at it this way. This is how you look at it. This is how it's done in sports. So I think that a difficult part for it is, as a lawyer, I understood what he was doing with the whole poking and where he was trying to provide the jury information about where to question the analysis, but it was so technical in some ways that it went over. I don't think all of his points landed with the jury. Certainly some did. And there were some that I think I saw a few notes getting taken, but a lot of especially the last hour and a half that Judge Bell then identified as being repetitive, it didn't go anywhere because he wanted a point conceded, and the expert was not conceding the point and was telling him he was looking at the wrong world. So that's what you'll see from a lot of the experts. And by the way, it's not unusual that he complimented the other side's experts. He said that he disagreed with their work in this case, and why, but he was complimentary of them, because these people, again, all do this type of work. Sometimes they're on the same side, sometimes they're on opposing sides, but it's really just about what you agree and don't agree with about their analysis in this case.
I think you summed it up the whole day really well, the end of the day, because that was the last 2 hours, right? It was, well, you didn't think of this and this. And he was like, yeah, but that's not how I came up with this, or that wouldn't have any impact on this, or I don't have an opinion on this. This is not what I was looking at. And then he would bring up something else and he'd be like, yeah, but I guess I'm assuming, Shannon, that Buterman's strategy was just to try to throw so much stuff at the jury and cast so much doubt that the jury's like, I don't know, it seems like they just see enough holes and they're like, I don't know, maybe this guy's not as credible or something. I
think that he was also trying to introduce and get somebody else to agree to the cost numbers that NASCAR perceives his damage valuation would have cost to use that big $1 billion number. And so I think part of that is to also start using their numbers in the narrative so that the jury begins hearing their numbers. And I think the things where he's like, well, that's not what's in this footnote, where he can directly point the jury to X and Y. Those might be more effective moments. I do think that once again, we came back around to a witness who kept saying, well, that's not what's in the documents, because this whole thing about why, if NASCAR has been around for all this time, how come there hasn't been a competitor? And he kept saying, because NASCAR was worried about a competitor at this point in time. And you can tell from these communications that NASCAR themselves were worried. And so these were the things that they were going to do to make sure that they didn't face a competitor, none of which involved making the sport more attractive for their existing teams. Like, if you're so worried about losing teams, in the terrible dating analogy of you're worried your partner is unhappy, you can make it really hard for them to leave, or you could just treat them better. Never on the list was treat them better.
Yeah.
Right. And so that was, and he also did circle back around to the general theme of there might be 13 teams who are okay not getting market rate share for what they are, because they don't, this is a take it or leave it system. And so just the fact that some people are okay existing in a monopoly doesn't mean that it is not a monopoly, and that's not a monopoly that's using unfair practices that are resulting in under market value of revenue coming into the teams. I did think it was interesting. He didn't say that what he didn't consider was the NASCAR merger with ISC, but he absolutely did consider the fact that NASCAR now owns all of the tracks that ISC used to own. So when NASCAR is putting out the 331 million, whatever it was, to tracks for exclusivity, that's just paying another side of their own business, right? It's one France family business paying another. And so that's why there was then that separate number for, he said, well, they wouldn't even have to pay the other non-France family owned tracks that, because they wouldn't have a need to do that if people wanted to be in their sport. So I thought that was how it is that it tied back to the theme of track access and control over tracks. So he wasn't offering an opinion as to if NASCAR purchasing ARCA or the ISC merger in and of themselves were anti-competitive monopolistic acts, but the fact that NASCAR controls about half the tracks is definitely part of his analysis. And in the list of things that he was pointing out, this would not bankrupt NASCAR. It would not be expected that NASCAR would just cease to exist because they have all of these resources. The debt that they've paid off most quickly is actually a reference to them paying off themselves, right? Big debt was the ISC debt.
A lot of talk about shortening up the trial because it's running long. And while there was efforts made, I think we all agree it's still running long. Even in an interjection today by the judge, it's still it's only going to go so far. So looking at this, we know the plaintiffs they said, hey, maybe Tuesday, maybe Wednesday. But I mean, even looking at the witness list, you got Jim France, you got Richard Childress, who I don't think it's
today got blown up by how long, when you left on Friday, it was 45 minutes with Marshall. It ended up, and then he got told find a way to shorten it up, and it ended up being 55 minutes, right? Then we lost half an hour for the shenanigans at 2 a.m. and 6 a.m. And then the examination of the expert is almost as long now as his direct, the cross-examination. So I can't really fault either team for the fact that it's going slow, but clearly both sides are blaming each other. That happened this morning when it's like, well, I thought you'd be done by now. You're taking up time during my day. Do I think it is realistic that we will get through all of the witnesses listed for tomorrow? No. The accountant should, in fact, be short, because all the accountant is coming in and doing is verifying the underlying data, particularly the data from the other teams, and just authenticating it and getting into the record. So I do believe that witness will be short. I don't know if they will flip the order of Richard Childress and Steve Phelps based on if they could get one in and out before a break. They might also have, agreed upon a time with Richard Childress under the belief that Steve Phelps would have started today. Therefore, Richard Childress could have started at 10:30 tomorrow. So I don't know. There might be some change among those. I think we will see the accountant, and then there might be some change among the order of Richard Childress versus Steve Phelps. But then we're finishing with Jim France.
All right. Well, Shannon, we'll hopefully get to see some of the people she came to see before she has to go back to Seattle. But thank you, Shannon. We'll see you in court tomorrow.
And I do have a little handy dandy chart I drew myself if people want to know the visual layout of what the room is like and what a room looks like when you have 2 sets of counsel tables and 10 attorneys up front, plus probably another 10 in the gallery. I don't know if I've ever been in a courtroom that had more attorneys. I'm more than happy to share my little a chart that I made for myself.
All right, check out S. McMinmy or whatever, SM McMinmy.
We're fine. They can find me by now.
All right, thank you, Shannon. We'll see you tomorrow.
The real question is, can you guys find your DoorDash?
We haven't ordered it. No, yet. We will be shortly. We have plenty more work to do. So see you later. Everybody else, for the rest of you, we're expecting that. First of all, thanks to those of you who made it to the driest episode we've had yet, but still appreciate you guys checking it out. Hopefully it wasn't too boring. We tried our best to explain it in a way that made sense. But tomorrow certainly we'll have much more to talk about.
We got some heavy hitters coming. We got RC coming at some point in the next few days.
What's your power rankings, Jordan, for these remaining plaintiffs' witnesses?
It's Jim France.
It's
Jim France for a very specific reason. We very rarely, if ever, interview Jim France. I've interviewed him once in the last 5 years.
I've never had a conversation with him.
Never?
No.
Oh, okay. So you very rarely hear Jim France do public interviews, almost never. You never hear him have to explain publicly his vision for the sport, decisions made, why you did this, why you did this, why didn't you do this. It's always the lieutenants, the other executives having to explain it. This is going to be really the first time I think ever have had a France family member sit on a witness stand and have to explain in depth, truthfully, the decisions they made and didn't make and explain their actions. This is unprecedented in the history of NASCAR.
Well, we'll see if that happens. Probably not tomorrow, but probably
sometime this week.
Yeah, sometime we'll go home eventually, maybe. But
should we do a good race poll for the trial? Was this a good trial day?
This wasn't.
No.
But
no.
All right, everybody. Thanks as always for listening, and we will talk to you next time tomorrow on the Teardown. See you, everybody.